I never thought my simple request to paint my front door navy blue would lead to a legal showdown with the president of our homeowners association. But that's exactly what happened when I crossed paths with Karen Wilkins, the self-proclaimed guardian of neighborhood standards and the most feared woman in Oakwood Estates. It all started last spring when I decided to freshen up my home's exterior. Before touching a paintbrush, I did what any responsible homeowner would do. I consulted our HOA guidelines. According to the documented rules, front doors could be painted in tasteful, subdued colors that complement the home's exterior. Nowhere did it specify which exact colors were permitted or forbidden. I chose a classic navy blue that matched my shutters perfectly and submitted my request form with color samples attached. 3 days later, I received an email from Karen with a subject line in all caps: "Violation notice, unauthorized color selection." Her message explained that my chosen shade of blue was excessively bold and disruptive to neighborhood aesthetic harmony. She demanded I select from a PRE-approved list of colors, all variations of beige and light gray. When I politely pointed out that these specific color restrictions weren't in our official HOA documents, she responded with a "The board has discretionary authority on aesthetic matters. Your request is denied." I've never been one to back down from unreasonable authority, so I requested a formal HOA hearing on the matter. That's when things began to get strange. The hearing was postponed twice for dubious reasons. When it finally happened, Karen presented what she claimed was an amended bylaw document showing that bright colors had been prohibited for 5 years. Something seemed off about the document. The font changed midway through and the page with the color restrictions looked crisper than the rest of the yellowing papers. After the hearing, where my request was officially denied by Karen's all too agreeable board, I decided to investigate. I contacted our neighborhood's previous HOA president, who had retired to Florida 2 years ago. When I mentioned the color restriction amendment supposedly passed during his tenure, he sounded genuinely confused. "We never passed any such thing," he told me. "In fact, we specifically decided against color restrictions because the board couldn't agree on which colors should be allowed." Armed with this information, I visited our county records office, where all official HOA documents are legally required to be filed. Sure enough, the amendment Karen had presented didn't exist in the official records. What I did find, however, was the original covenant with no color restrictions beyond the vague, tasteful, and complimentary language. When I brought this discrepancy to the attention of 2 other board members, they seemed uncomfortable, but insisted that Karen must have the correct version. "She's very organized with the paperwork," one of them assured me nervously. "She probably just hasn't filed the latest amendments yet." Not satisfied with this explanation, I sent a formal letter to the entire board requesting clarification on the document discrepancy. 3 days later, I returned home to find a certified letter from the HOA, or more specifically from Karen herself. Inside was a notice of multiple violations allegedly occurring on my property, along with a fine of $900. The violations included improper garbage bin placement, unauthorized garden border stones, and excessive holiday decorations in April when I had absolutely no decorations up. This was clearly retaliation, but I wasn't going to be intimidated. I took photos documenting the absence of these violations and requested another hearing. To my surprise, Karen responded by filing for an injunction against me, claiming I was harassing the board and disrupting HOA operations. The most shocking part, she included affidavits supposedly signed by my next-door neighbors testifying to my aggressive behavior and property violations. I knew immediately that something was wrong. My neighbors, the Johnsons, had been on a 3-week European cruise. There was no way they could have signed those affidavits on the date indicated. When I called them to confirm, they were outraged that their names had been used without their knowledge or consent. It was time to take this matter to a real authority. I consulted with an attorney who specializes in HOA disputes, and she was visibly disturbed by what I showed her. "This isn't just an HOA overreach," she explained, her expression serious. "Falsifying legal documents and forging signatures are criminal offenses. We need to bring this to the court's attention immediately." We filed a counter-suit against the HOA and Karen specifically, including all the evidence of document tampering. I had collected. The judge assigned to the case, the Honourable Judge Marcus Rivera, was known for his non-nonsense approach to frivolous litigation. He scheduled an emergency hearing to address the forgery allegations before proceeding with the original injunction request. The day of the hearing arrived, and I was a bundle of nerves as I entered the courtroom. Karen sat on the opposite side, immaculately dressed in a tailored suit, her posture radiating confidence. She barely glanced in my direction, instead busying herself with organizing stacks of papers with her attorney, a slicker-looking man in an expensive suit. When Judge Rivera entered, the proceedings began with Karen's attorney presenting their case for the injunction. He painted me as a troublemaker who refused to comply with established rules, waving the suspicious amended bylaws as evidence. When it was our turn, my attorney calmly presented our evidence, the official county records, statements from the former HOA president, and most damning of all, sworn affidavit from the Johnsons stating they had never signed the documents Karen submitted and providing proof of their absence during the supposed signing. Judge Rivera's expression grew increasingly stern as he examined the documents side by side. These signatures don't even appear to match the Johnsons' known signatures on file, he noted, peering over his glasses at Karen, who had begun to shift uncomfortably in her seat. Miss Wilkins, did you personally witness these signatures being applied to these documents? Karen cleared her throat, her confident demeanor cracking slightly. I received them by email, Your Honor. I printed them out for submission. The judge asked to see the emails. Karen's attorney whispered something to her and she fumbled with her phone before claiming she couldn't locate them at the moment. Judge Rivera was not impressed. What about these HOA amendments? The judge continued, holding up the suspicious pages. The county has no record of these, yet you're enforcing them as legally binding documents. Karen's response was a rambling explanation about administrative delays and paperwork backlogs. The judge cut her off mid-sentence. This court takes a very dim view of document falsification. Miss Wilkins, I'm ordering a forensic document examination of all materials submitted. In this case, Karen's face drained of color. Her attorney requested a brief recess, which the judge granted. When we returned to the courtroom 30 minutes later, Karen's demeanor had completely changed. Her earlier confidence had evaporated, replaced by visible anxiety as she repeatedly whispered to her attorney. The forensic examiner didn't need much time to confirm our suspicions. The amended bylaw pages were recently printed, not 5 years old as claimed. The paper stock didn't match the rest of the document. Most damning of all, digital analysis of the Johnsons' signatures revealed they had been electronically copied from HOA membership forms and pasted onto the affidavit. Judge Rivera's patience had clearly run out. Miss Wilkins, stand up, he commanded, his voice resonating through the now silent courtroom. Karen rose shakily to her feet, her eyes darting around, as if seeking an escape route. Based on the evidence presented today, I'm dismissing the injunction against the defendant. Furthermore, I'm referring this matter to the District Attorney's Office for investigation of document fraud, forgery, and perjury. Bailiff, please take Miss Wilkins into custody. The collective gasp in the courtroom was audible as the bailiff approached Karen, who stood frozen in disbelief. This is ridiculous, she finally sputtered, her voice rising to the shrill tone I had become all too familiar with in our HOA meetings. I am the president of the Oakwood Estates HOA. You can't treat me like a common criminal. But Judge Rivera was unmoved. The law applies equally to everyone, Miss Wilkins, regardless of their position in a homeowners association, as the bailiff led a now weeping Karen away in handcuffs. The judge addressed me directly. Sir, you're free to paint your door any color you wish according to your actual HOA covenants, and I suggest the remaining board members conduct an emergency election to replace their leadership. Karen looked back over her shoulder as she was escorted out, her mascara running down her cheeks, her expression a mixture of rage and shock that her perceived authority had proven meaningless in the face of actual justice. The last thing I heard her say before the courtroom door closed behind her was, "This isn't over. I've given everything to this neighborhood." The judge set her bail at $25,000 and ordered her to surrender her passport while awaiting trial on multiple felony charges. When the gavel came down, finalizing this initial hearing, I felt a weight lift from my shoulders that I hadn't even realized I'd been carrying.